Chapter 6, Protecting the Idea and Other Legal Issues for the Entrepreneur. So, what's intellectual property? Well, intellectual property includes patents, trademarks, copyrights, and trade secrets. These are important assets for each entrepreneur. All business is regulated by law. Be aware of the regulations affecting your new venture. Different stages of a company's growth require different legal advice. Never, ever skimp on the legal aspect of starting a business. The rug can be pulled out from under your feet overnight, both in terms of protecting your intellectual property, but also when it comes to liability. You can just lose everything. Go ahead and set aside some money to have a good lawyer. Okay? Evaluate your needs carefully before hiring a lawyer. So, how do you choose a lawyer? The entrepreneur does not have the experience to handle the possible risks associated with difficult laws and regulations where they practice. Okay? The lawyer may work on a retainer or a one-time fee. As your business grows, it's much more likely they'll work on a retainer. Legal advice is necessary to ensure the appropriate decisions are being made at each step of establishing a new venture. Now, what are patents? Well, a patent is a contract between the government and an inventor. The patent gives the owners a negative right. It just gives them a right. It gives them ownership of something that they've come up with. So the types of patents include utility patents, which grants owners protection from anyone making, using, and or selling their invention. Someone else's invention that has the patent. So there are design patents, which cover new, original, ornamental, and unobvious designs for articles of manufacture. There are plant patents are issued for the same provisions as utility patents and covers new plant varieties. So some people can splice different varieties of plants and come up with an all-new plant. You need a patent on that. Patents are issued by the Patent and Trademark Office, PTO, and this is the first to file system that rewards firms that file quickly. So people could see your invention and quickly copy it and file it before you, and guess what? They're going to be the ones that get the patent. So this isn't something you want to wait on. International patents, concerns over international imitations and knockoffs, result in an international patenting being a strategy for many startups because you can easily get ripped off overseas. The USPTO established the Office of International Patent Cooperation, which has established a harmonized patent system that has gone international. So you can start in the US and patent it in other areas. Now, does this mean people won't rip you off and maybe do cheap imitations? No, of course not. They're still going to do that, but this gives you recourse to take action on them in international courts. Joint efforts between the USPTO and the European Patent Office establish a common classification system. The global dossier, allows a patent application to be applied to 5 of the largest patent offices in the world. So you can get some pretty broad reach with your patents. The patent application process, they file of a provisional patent application. So this is something as your patent's being approved, you have a provisional patent to establish the date in the invention conception. So when did you come up with this idea? So someone, even if they didn't file a patent and they did it before you, what you say, if you're the first, sets the date that this thing was created. So the actual filing of a patent must occur within 12 months of you inventing a product, or trademarking something you came up with. So a patent application is divided into sections. So there's the introduction section. It's the background and invention advantages. So things that you're doing that are unique that gives the product or service an advantage. The description of the invention section, the engineering specifications, materials, and components. These can get quite detailed, and this is why you need a patent attorney involved. The claims section establishes the criteria for which infringements will be determined. So how are people likely to copy what you've done? Again, you need technical help here. That's why we started out this section with lawyers. Applications should contain a declaration signed by the inventor themselves, and when the application is sent, the invention becomes patent pending. So you have some initial patent protection. Again, these presentations here are not meant to be thorough or replace the reading. You can learn so much more in the reading. What is patent infringement? The entrepreneur can infringe on someone else's patent. Yet many inventions are improvements on existing products. So copying and improving a product may be legal and a good strategy. If your copying is possible, licensing may be an option. So can you license your product or service to someone else that they can improve upon it? The use of the internet and the USPTO website you can use the internet and the USPTO website to check on existing patents. If in doubt, hire a patent attorney. And I'm telling you, if you have something worth pursuing, you need to hire a patent attorney. So what business methods, patents can we use, and what can we learn about? So with the internet, you've had so many great things emerge when it comes to idea sharing, but also business method patents. Amazon owns such a patent on single click buy feature. So like the buy now button on Amazon, literally they have a patent on it. Priceline claims a patent on a service where a buyer can submit a price bid for a particular service. So your Priceline's like a hotel, rental car, and airfare, and you can put in a price. They patented that. So the way your business methodology, it can be patented. So Amazon, again, the buy it now. Priceline with the you bid on a price. They've patented those types of things. Many firms can use these patents against their competitors, so they have a competitive advantage. The PTO, Trademark Office, reviews these patents through Patent Trial and Appeal Board. Not all startups have a patentable, is that even a word? I feel like they made that up. Product, something they can get a patent on. But a unique marketing plan may provide a competitive advantage. Sometimes you may not be able to patent, say, a buy now button, but the way you market it can make it feel like you have that advantage. So a trademark, now what's the difference between a patent and a trademark? Well, a trademark may be a word, a symbol, or design combination that identifies a source of certain goods. So a trademark can last indefinitely as long as it continues to perform its indicated function on renewable terms every 10 years. So think of like the Nike swoosh, that thing's trademarked. People can't just put the Nike swoosh on things and sell it. Although they try. Filing of a trademark request within the PTO has 4 requirements: completion of a written application form, a drawing of the mark, 5 specimens showing the actual use of the mark, so it has to be in use, and the appropriate fee because the government's going to get their pound of flesh. Unopposed marks are registered, and the process can take up to 13 months. But again, you've started the wheels going just like you did with patents, so you have some recourse there. Now, what's a copyright? A copyright protects original works of authorship. So it does not protect the idea, which can be used in another manner. Copyright law is relevant due to the internet and file sharing. Streaming content and social media postings are a concern because people can steal. But if you write a play, you're going to want to get it copyrighted. If you write a song, you're going to want to get it copyrighted. A poem, etc., etc., a book. Copyrights are registered with the Library of Congress, and the process does not require an attorney. These are a little bit easier to get. Requirements are 2 copies of original work and appropriate fees, because again, the government's going to get their pound of flesh. And the copyright terms are the life of the author plus 70 years. Pretty cool, huh? Trade secrets and non-competition agreements. An entrepreneur may prefer to maintain an idea or a process as confidential and to sell or license it as a trade secret. Hello, KFC secret ingredients. Non-compete agreements protect valuable assets such as product information, clients, marketing ideas, unique strategies. You see a lot of non-compete agreements when you have highly professionalized or technical sales, although it varies by state whether those things are actually enforceable. South Carolina, which is where I'm recording this, doesn't do a whole lot for non-compete agreements. It's employment at will, so they typically don't fly well in this state. Common laws in each state cover trade secrets. So again, they vary from state to state. Employees signing confidential information agreement may be sued if they breach the agreement. So if you put all the trade secrets out there, if you share it on Wikipedia or that type of thing, you could get pursued in court if you sign a confidential agreement. The entrepreneur may restrict confidential information. Today's tendency is to share more information with employees. So if you have something confidential you need your employees to keep under wraps, you may want to have them sign a confidential information agreement. So proper protections help avoid serious future problems where you lose all your trade secrets. So to maintain secrecy, you need to funnel sensitive questions through one person, provide escorts for all visitors. I once worked at a manufacturer where everyone every day had to turn in their phone before they went to their desk because phone cameras could be used to commit corporate espionage. I feel like people's heads would explode today if you tried to take their iPhone from them for like 8-hour period. That would be crazy. But anyway, avoiding discussing business in public places, keep travel plans secret, control information presented to employees at conferences and journals, use locked file cabinets, password shredders, have employees sign non-disclosure agreements, debrief departing employees on confidential information, avoid faxing sensitive information, because if you fax it to the wrong spot and it gets in the hands of your competitor, you have a breach. Mark documents confidential when needed. These are all things you can use as a company to maintain secrecy. Preparing non-competes, so non-competition agreements, protections against leak of trade secrets is difficult to enforce. Legal action is possible only if the secret is revealed. So you have to have your paper trail and then also prove that someone else violated it. Consider the following points when preparing a non-competition agreement. Determine if the employee can harm the company if they left. Hire a competent labor law attorney to make sure the agreement is fair and enforceable. Provide incentives for signing a non-compete agreement hiring. Say, hey, your sign-on bonus is contingent on you signing this form. Make sure they're well informed, but also enforce it. Specify what is included in a non-compete information. Consider other options such as non-piracy and non-disclosure agreements. It really depends on what type of industry you're in and what is the likelihood of the information getting out. Licensing is information and technology protected by a patent, copyright, or trademark that may be licensed to another party for a royalty fee. Licensing has significant value as a marketing strategy. A patent license agreement specifies access to a patent. Licensing a trademark generally involves a franchising agreement. A lot of fast food, franchises are out there. They're licensed to be able to use the golden arches, whatever it is they're associating with. Copyrights are also popular licensed properties. Celebrities license their name and image. So you have to, there's a lot of licensing out there. So you have to be on top of that. And a lot of entrepreneurs actually start out as being licensed with other people. So they can, use that information, use the golden arches. They can associate with some type of franchise. This is all through licensing. A lot of what you see, and you probably don't realize on a daily basis, is actually licensing. Product safety and liability. There's that big word, liability. The Consumer Product Safety Act created the commission with the power to prescribe safety standards for products. The act was passed in 1972, amended in 1990 and 2008, and probably since then. Large fines and recalls are typical for products deemed unsafe. McDonald's had to recall, for example, some Happy Meal toys that caused choking. IKEA had to recall some children's dressers, probably because the parents couldn't put them together if they tried. No, it was actually a toppling issue that the dresser would fall over and crush a child, which is actually very alarming. And entrepreneurs must be aware of the how to treat recalls, especially in high-risk products such as food and toys and dressers that might fall on people and also drive the people who are trying to put them together crazy. IKEA, man, what is that? You got to think about insurance here. An entrepreneur should purchase insurance in the event that problems do occur. You need liability coverage. Most firms consider coverage in specific areas as a way of managing risk in the business. Some insurance is required by law and cannot be avoided. Okay, if you're run like a fitness business or something like that, you better have a lot of liability insurance because someone's likely going to get hurt. Consider all of the changes to the Affordable Care Act in 2010 before deciding on an insurance plan or program, not only for your own employees, but also for how it covers liability. There was a lot in that act that changed things around liability and not just healthcare. Advice and information on insurance is available through the Small Business Administration, largely for free. But again, I would really, really, really strongly encourage you to get an attorney in this area. Sarbanes-Oxley Act. Congress passed the Sarbanes-Oxley Act in 2002, amended in 2010. Congress exempted small businesses from Section 404. Let you read a little more about that. The law has many provisions, but an overview includes CEOs are required to vouch for financial statements. They're on the line because we had a thing through the 90s and late 90s and early 2000s where, quite frankly, they were just lying on their financial statements to get a higher stock price and then a windfall. Directors must meet responsibilities of internal auditing and control. Any attempt to influence an auditor may be seen as a criminal act. A lot of this came out of a lot of financial malfeasance that was happening during that time period. The act may discourage qualified persons from sitting on important boards because they become responsible then for what the company reports. You're on the hook there. That's why I would always say, hey, be careful on what boards you serve on because you could turn around and get sued. The entrepreneur may wish to set up a board of advisors rather than an extended board of directors. I always encourage people to do this approach. Get a board of advisors, just some people you trust that can give you advice in areas that you need before you make it real formal. Because as you bring them in and your company grows, if you make a more formal extended board of directors, which you'll eventually need as you get successful, you actually put them on the hook for a little bit of liability. Contracts. A contract is a legally enforceable agreement between two parties as long as certain conditions are met. Some business deals are informal and concluded with a handshake. If the deal cannot be completed in 1 year, do not rely on a handshake. I'm not real big on handshakes anyway. I like looking you in the eye and trusting you and shaking your hand and saying, hey, we got a deal. But it really doesn't matter until you have it in a contract. There is some enforceability within a less than 12-month period on a handshake deal, but there's just no guarantees. Because the courts insist on a written contract for any transactions over $500. So keep that in mind. Just get a contract. Draw up a contract. Pay a lawyer. I know it's money up front, but pay a lawyer. Draw up, if I could talk, your contracts in due time. Any deal involving real estate must be written to be valid. Can't sell land without a written contract. And there's a lot of rules to that. Before signing a contract, do the following. Understand the terms and conditions of a contract. Cross out anything you do not agree to. Do not sign if there are blank spaces. Cross them out. Make a copy of your file for your files after signing. Chances are, if you're presented a contract, it's coming from their attorney. If you think you're bold enough and smart enough to sign it without your attorney looking at it because you don't have an attorney, do not sign it. Get yourself an attorney. Get yourself an attorney. Get yourself an attorney. Get yourself an attorney. They're worth it. A couple things are really worth it in this type of entrepreneurship. Getting yourself an attorney and hiring yourself a great accountant. That is Chapter 6, Protecting the Idea and Other Legal Issues. Again, a high-level overview does not replace the reading. I'll see you on the next one.